Oh, I think I see one.
Ooh, Heart of Atlanta Motel. It looks really nice. I bet it's bubbling with Southern hospitality. Hi, how are you?
Hello, welcome to the Heart of Atlanta Motel. How may I help you?
Oh, we'd like to rent a room, please.
Oh yeah. Oh no, not you.
Why?
We don't take your type here.
Is it because I'm a Gemini?
We are trying to run an upstanding quality motel service, and in order to do so, we must take pedigree into account. Proper pedigree is imperative to maintaining the proper hotel culture. We don't take black people. Go away. I'm just following policy.
She was just so rude about it. We were just trying to be loyal customers, and she's like, we don't take black people here.
I mean, a normal person would have gotten over it, but this time it got personal. Hello, I'd like to get a suite.
What's your name?
Susan White.
Get out.
We got you flowers.
No. No. Get out. No. Just
Okay.
leave. Get out. I have rights! This motel is my business, and the government shouldn't be getting wound up in it. If I'm not selective about who my customers are, I'll lose business. You think that upstanding white citizens will want to sleep in the same beds where lower races have slept? They'll be disgusted. I'll lose all my fortunes and investments. The government can't just go swinging control over whatever it deems to be a public facility and think that people won't see this blatant constitutional violation. This isn't just a facility. This is my livelihood. The Civil Rights Act violates my rights as a free American citizen. This is tyranny. So, thank you, Your Honor.
We, the three-judge federal court of the United States, uphold the right of Congress to pass the Civil Rights Act of 1964. We have no affiliation with this case whatsoever.
We're not biased at all.
This is ridiculous! The Civil Rights Act has to be unconstitutional. It goes against my right to freely operate my private business. I'm basically a slave to the government. Wait, hang on. That's in the Constitution too. The government's enslaving me to serve these stupid black people. That's it. I'm going to the Supreme Court.
Oyez, oyez, oyez. Supreme Court of the United States is now in session. Those having pleas to enter and claims to prosecute, draw nigh, and you shall be heard. God save the United States and this honorable court. Be seated and give your attention to the court.
Today, the U.S. Supreme Court will hear the arguments of the Heart of Atlanta Motel, the petitioner and appellant versus the United States of America, the respondent and appellee. First counsel for the petitioner, Heart of Atlanta Motel, you may begin your argument.
May it please the court? My name is Burke Marshall. I represent the Heart of Atlanta Motel. Today, I shall present the argument that Title II, Section 201A, B1 and C1 of the Civil Rights Act of 1964 are unconstitutional, as the prohibition of racial discrimination in public accommodations exceeds the congressional power to regulate interstate commerce under the Commerce Clause and violates other parts of the Constitution. The facts of this case are briefly that motel owner Morton Rolston filed suit in federal court, claiming that these parts of the Civil Rights Act exceed the congressional powers under the Commerce Clause and violate his Fifth Amendment rights, as his right to choose his customers and operate his business was violated, resulting in unjust deprivation of property without due process of law and without just compensation. Thank you, Your Honor.
The United States of America, you may present your argument.
May it please the court. My name is Charles Goodson, and I represent the United States of America. Today, I will represent the argument that Title II, Section 201A, B1 and C1 of the Civil Rights Act of 1964 are constitutional under the Commerce Clause of the Constitution and do not violate the Fifth Amendment rights of the appellant. The 3/4 of the clientele at the Heartland Motel are interstate travelers. The motel is readily accessible to Interstate Highway 75 and 85 and State Highway 22 and 41. The appellant solicits patronage from outside the state of Georgia through various national advertisement medias, including magazines of national circulation and over 50 billboards and highway signs soliciting patronage for the motel. The inability of Negroes to access accommodations interferes significantly with interstate commerce and travel, so Congress has the authority and responsibility to correct this error. Furthermore, the Fifth Amendment does not forbid reasonable regulation, and the consequences of the act do not constitute a taking within the meaning of the amendment. Thank you, Your Honor.
May it please the court? The Civil Rights Act of 1964 further violates the 13th Amendment, as forcing private businesses to provide service to Negro customers is involuntary servitude. The 13th Amendment protects the right of Americans to choose if and who they serve, so forbidding business owners from choosing customers based upon race infringes upon that essential right. With regards to the argument of the Attorney General, accessibility of a facility does not qualify as grounds for business rights to be denied. The business operates only in the locality and does not have operations in other states, so it cannot be categorized as interstate commerce under the Commerce Clause. I see my time is up. Thank you, Your Honor.
May it please the court? The 13th Amendment refers to involuntary servitude, which is defined as labor performed as a result of coercion, force, or imprisonment. Morton Rolston has chosen freely to own and operate the Heart of Land Motel, and is therefore must abide by the laws and regulations set by Congress under the authority granted by the Constitution under the Commerce Clause. Furthermore, as the Heart of Land Motel is specifically intended to serve travelers, it cannot be denied that the motel qualifies as interstate commerce and is therefore subjected to congressional regulation. I see my time is up. Thank you, Your Honor. Thank you, counsels, for your presentations. The court will now retire to render a decision. The United States Supreme Court is now adjourned.
Opa!
The Supreme Court upholds that Title II, Section 201A, B1, and C1 of the Civil Rights Act of 1964 are constitutional under the Commerce Clause of the Constitution and do not violate the Fifth Amendment right of the appellant.
Now, what's like the most cheesy song ever? He's very, very extraordinary. Whenever you're ready.